Hi, everyone. I'm going to give everyone a minute to log in, and I'll get our closed captions up and running as usual. You all know the drill by now. Okay, the closed caption should be up and running, so you'll see the red live box at the top of the screen if you want to follow along there. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services, and I'm excited to welcome you to this extremely relevant topic that we have not covered before. So I'm really excited to have Ha Dao here. She's going to teach us about family guardianship, and she's an associate at Christy Arkovich, and she has 28 years of experience. And her focus is on advocacy for the elderly population, or as I like to call them, the experienced population. So I'm really happy to have her here today, and I do want to thank Lynn Drysdale at Jacksonville Area Legal Aid for connecting us with Ha Dao for this presentation today. I will be running the PowerPoint, so I won't be able to monitor the chat as much as I usually do, but go ahead and type your questions in the Q&A box. That way I can find them at the end of the webinar. And CLE has been approved for this webinar, so I will announce that at the end. And Ms. Dao has been generous enough to share her PowerPoint with us, so that will go out tomorrow along with the recording. So without further ado, welcome, Ms. Dao.
Thank you so much. Thanks for being here with me. I am excited to talk to you guys about the one subject matter is near and dear to my heart, which is guardianship. And the focus, as I indicated in the title, is on family guardianship and why we do that. So the first thing that I wanted you to know is under what scenarios do we deal with guardianship, or how does it arise? And more often than not, you and I don't think about these issues, but most of our elderly folks live, for the most part, they like to live independently. Some of them live far away from families. For example, my parents live in Florida, and most of their families live elsewhere, Seattle, Texas, Hawaii. So for a long time, the elderly person can manage to live independently, but usually, as you know, the scenario is a married couple, one passes away, and the other is trying to stay at home and carries on. And one medical mishap is all it takes for the person to go down. They get hospitalized, they go to rehab, they come home, and now they need a lot of help. So because of a major medical event, a lot of them will find themselves in a place where the bills for the household are not being paid. They cannot, no one can access their home to get, the checkbook or, whatever that they need. And for the most part, elderly people suffer from certain conditions that can produce a transient incapacity. What comes to mind is UTI, urinary tract infection. Before I worked with the elderly population, I never knew the impact of UTI on the brain. But as some of you have found out, it really wreaked havoc to the person's mind. They become literally incapacitated when it comes, as far as their cognitive ability. They started to hallucinate. And so even though it's a transient condition, it prevents them from taking care of themselves during the period of time that they're receiving rehab or following a hospitalization. So, it's lots of time people say, well, I have my daughter or my son on the account and they can make the payments and they can help me, do most things. But the most important document that we should have is the durable power of attorney. We don't think of ourselves as suffering from a disability or any kind of incapacity at any given time. But if it does happen, it's really helpful to have somebody who can act in our stead. So lots of times our elderly operate without the durable power of attorney. Something happens and they can't do the most basic things to carry on with their life. The other scenario that I have come across is when the elderly is experiencing exploitation by someone, and it doesn't have to be any organized group or anything like that. For example, I had a case where the hairdresser was taking advantage of her client, the elderly person, a dog groomer was using a durable power of attorney or some documents to try to get to move money away from my client's account. Lots of times you will hear from neighbors and friends who say, I'm concerned about my friend, my neighbor. It seems that she has memory issues and can't do certain things. I had a case where a realtor who came upon the elderly person realizes that there was some issues with capacity, and she was the one that petitioned for guardianship. So, you get referrals from all directions, but at the same time, you yourself, being down in the trenches, working with people, you will recognize signs and symptoms of diminished capacity. And it's a progressive disease. So you're going to see that, the signs that we see as nebulous, sometimes it's an indication of a deeper problem. So guardianship arises when we don't have a document that allowing some representative of the elderly to act for him or her. And it happens much more often than we care to know. So the next thing that I want to discuss is really give you guys an overall of the guardianship system and why we feel that family guardianship is important. So the guardianship proceeding is a court proceeding. It can be voluntary or involuntary. And so one question that comes to mind for you is, if you're talking about somebody who lacks capacity and has to be under guardianship, why would it be voluntary, right? And the answer is sometimes, so the guardianship has twofold. One is over the person and the other is it's over the person's financials. And then the other is over the person's healthcare and social aspects. So if a person feels overwhelmed in terms of handling his or her finances, she can voluntarily seek guardianship. And the court would appoint someone to handle the money matters and helping the person to go, to go about her daily life. So it's a court proceeding, and the petitioner is someone who is interested in the elderly's well-being, recognizes an impairment that has to do with their cognitive ability, and petitions the court for guardianship to be imposed. But you have the scenario when you have more than one family members. So sometimes I run into a situation where one sibling decides that mom and dad, mom or dad did not have the document necessary to carry on and initiated a guardianship proceeding. And then another sibling said, no, wait a minute, my dad is not incapacitated. You're only doing this to, remove control and independence away from dad. So I'm going to oppose. And so you will find at times the guardianship has competing petitions or objections to the petition that's being filed. I put down here the governing statute is section 744.331 and the Florida Probate Rules and Administrative Code, which is the standards of practice for professional guardians, essentially. But the process is that the court, upon a petition being filed, will assign or appoint a panel of experts to go and have a visit with the alleged incapacitated person. We call that person AIP, and have an examination by each of these committee members with regards to the person's cognitive ability and whether or not capacity is present. Now, under Florida law, it doesn't take much for you to be a petitioner. You only have to be an adult. You don't have to be related to the person. You don't have to have any interest in the person's any legal means. If you see something, you say something, and you could be the petitioner. So the proceeding is actually a legal proceeding to remove civil rights. So when you think about it, this person under guardianship is really to have, the court is going to remove certain rights of this person so that someone else can be delegated those rights and exercise them for the ward, right? So once incapacity is established, an appointment of a guardian is then being made, and then the person's medical care, residence, and other matters, and financial matters will be under the hand of the guardian. So let's talk a little bit about the rights being removed from the person. So some of the rights are they can be delegated, but some cannot be. I give you an example with the rights that can be delegated, and these are rights to contract. The guardian can sue or defend lawsuits against the ward. The guardian can manage or give property away, apply for government benefit, to determine where the ward should live. And it's very important when you think about the person's independence. If you have someone who is now making decisions about where you live, and most concretely is to, for the guardian to say, we don't think you're safe at home, we don't think you can live alone at home, and so we're going to put you in a nursing home. So that's a pretty profound right that the person has that is being removed under guardianship. One interesting, and then you think about the other rights that cannot be delegated, and it's logical. For example, the right to vote, that cannot be delegated. The right to marry, interestingly enough, the Florida Supreme Court had the occasion to decide the issue whether or not someone who's under guardianship can marry. And their decision, Smith versus Smith, holds that the right to marry is really connected to the right to contract. And if you think about it, it makes sense, right? So if the right to contract is removed, then the answer is you cannot get married. If you want to get, if you want to get married, while your right to contract is removed, then you're going to have to seek court approval in order to validate that marriage. So those are the rights that are associated in guardianship, and whether or not some of them can be removed and some of them can be left intact. Lots of time I will see most of these rights being removed, and the right to vote is retained. The right to marry is significant in the scenario where the person is incapacitated and somebody seeks to marry that person for financial gain. And so you can see where the court comes into the picture and decides whether or not the marriage was appropriately taking place in the guardianship context. So before a permanent guardianship case can be installed, you can file for emergency temporary guardianship. And the difference between the ETG and the guardianship proceeding is that the ETG, the burden for the petitioner in that situation is not incapacity. The court in an ETG proceeding doesn't determine whether or not the person has capacity, but the petition has to allege imminent danger to physical, mental health, safety, or the property of the person's being wasted, misappropriated, or lost unless immediate action is taken. So if you go into court and you petition for an ETG and you're successful at obtaining it, the ETG is going to last 90 days or until a permanent case can be made. So in the ETG, there's no examination of the AIP. There's no incapacity involved. You simply allege facts to show that there's an imminent danger if the court doesn't take immediate action. The ETG lasts for 90 days. It can be extended for another 90 days if the emergency persists. However, within that 90-day period, chances are the full-blown guardianship case would have occurred and an appointment of a guardian might have been made or not made. So these are court proceedings. So you keep the issue of due process in mind. The AIP has to be served. The next of kin has to be served. And there are other people who are labeled or designated as interested persons, and they may or may not be relatives, but that they have expressed an interest and shown a connection sufficient for them to be involved in the process. The evidentiary hearing is held by the court to determine several factors. And one of them, the most important one, is whether or not there is any less restrictive means. You're going to hear this front and center in a guardianship proceeding, which is the court's, which is the idea that the court should not take away people's rights lightly, right? So if the person while they were well and they have put a lot of thoughts into who's going to be handling their financial affairs, who's going to be handling their healthcare issues, then we should really give those documents deference, right? So at the same time that there is a petition before the court, the first question the court is going to ask is, are there any less restrictive means? Is there a durable power of attorney? Is there a living will? Is there a designation for pre-need guardian, which is a document that says, if I ever succumb to incapacity, this is the person that I want to act as my guardian. Yes, you can have that person name beforehand, and you can change that person out as well if you don't think the first person you designated is capable or willing. So the evidentiary hearing encompasses that particular question. The second question is whether or not this person is incapacitated. And you go back to the examining committee members. They each have to file a report with the court within a certain period of time. And their report has to do with the person's ability to perform certain things, including whether or not they can handle their daily living activities. So incapacity is really a matter of these examining committee members, their findings, and it's majority rule. So if 2 out of the 3 says that there's no capacity, then the guardianship is going to be installed. If 2 out of 3 said no, this person still can function and guardianship is not necessary, then the court would impose a guardianship. There are situations where the examining committee members would find that there's some degree of incapacity, but not sufficiently enough to really remove all rights. So then in their report, they're going to specify what rights should be removed. Lots of times, the committee members will come back and say, perhaps, this person needs some help with money matters, but not as far as where they how they live and how they function. They should be independent in their decisions. Then you have that situation as well. And then the last issue in a guardianship proceeding is who to appoint as a guardian, right? So the decision on who to be appointed by the judge is a discretionary act, but it has to be supported by logic and justification, and it has to be founded on substantial competent evidence, and that makes sense. So that is the standard of proof, substantial competent evidence. So when you think about the qualifications of the guardian, the statute says that a person who is relating to the ward or the AIP does receive preference in the appointment, but it's not a matter of mandatory. The judge doesn't have to appoint a relative. In fact, in many cases, when you have more than one relative fighting for the right to be appointed as guardian, the judge often would say, well, if there's a tug of war, I'm going to appoint a professional guardian because I don't know which one of you is a better person to serve. And so it's best to find somebody else. The appointment, again, made by the court can be plenary, which covers both person and property, or just one aspect. It could be just over the person and not property. But at the same time, though, you're going to find more often than not the guardianship over property is more commonplace, essentially because the person may be functioning just fine, but very confused, and he or she would find it difficult to pay the bills, to look at, all incomes and expenses coming in and not knowing how to handle it, or, late payments and some missteps in handling the mortgage, for example. So because it is a court proceeding, everybody involved, typically, is represented by an attorney. Now, the alleged incapacitated person has to be appointed an attorney, and that's the job of the court. The petitioner who files the petition also is represented by an attorney. The proposed guardian is also represented by an attorney. And if you have competing petitions or conflict among family members, then you can have more than one person, interested persons who is represented by an attorney. I have been in proceedings of guardianships where there are 3, 4, 5 different lawyers. Hopefully you won't have that significant degree of a fight, but it happens every now and then, especially in a family that has more than one child, because the family dynamic is something that, it's difficult to explain, and the court has to resolve that within the guardianship proceeding. So in Pinellas County, our examining committee comprises of 3 professionals, MD, a PhD, and a nurse. In other counties, not necessary. I have done work in Volusia County, and I understand that in that county, the examining committee, one of the examining committee members can be a guardian, a professional guardian. So it really depends on the county that you're in. The report of the committee members have to include a physical examination, a mental health examination, and a functional assessment. And in actuality, they visit the ward for anywhere between 30 to 45 minutes. If they do more work, it's an hour. But overall, it's a very brief period of time. The committee members like to go out to where the ward lives or the AIP lives, so they can see the living situation. They can make a better assessment. Lots of times they have to do it at the nursing home or at the rehab center where the person is currently residing. During COVID, it has been very difficult for examining committee members to go out there and see the AIP in person and make the assessment as they need to. So there are some limitations to that. But keeping in mind that if it's your mom or your dad, and given the progressive nature of dementia or Alzheimer's, or even a slight case, we all know that the elderly person has good days and bad days. And in the morning, as opposed to the afternoon, they may do better or they may do worse. So even with 3 different people coming out and evaluating the person, it doesn't mean that their evaluation is significantly in depth. So we also have cases where the lawyer for the AIP would contest the issue of incapacity and tells the court, listen, my client may need some help, but it is not to the extent that a guardianship is appropriate. So the job for the attorney representing the AIP isn't simply to roll over and go with recommendations of the examining committee members, but the lawyer has to really understand the client sufficiently enough to know whether or not a contest should be launched. So let's look at the next slides. So the qualifications of the guardian, and I'm talking about guardian in general. It's not, really, it's not a high burden, for someone to be acting as a guardian. The requirements that you need to be a state resident who's 18 or older. If you're not a resident of the state, but you're related by blood or by marriage to the AIP, you can serve. If you're adopted or if you're a parent of the ward, you can serve. And I forgot to mention at the outset of this training is that guardianship isn't just for old people. Guardianship can also be established for disabled persons. And in that situation, we call the guardian a guardian advocate, and it goes under a different statute, not this particular statute. But at the same time, you can have a relative serve as guardian. So it can be a spouse, a brother, sister, uncle, aunt, niece, nephew. We have all of those people at one time or another being appointed in my caseload. And the last one is that a guardian can be the spouse of a person otherwise qualified. And then you say, well, what does that mean? So I have a daughter of an AIP who is not able to handle the financials, but her husband is an accountant and can handle work like that very well. And so he seeks to be appointed, but at the same time, they can be co-guardians if they wanted to. All they need to do is really present the case to the court that it takes more than just one person to help the AIP And I have seen appointments of co-guardians in my service as an attorney, as a guardianship attorney. So then you talk about, well, those are the qualifications. What about the disqualifications? And commonsensical, right? If you have a felony conviction of some sort, you can't serve. If you are not able to discharge the duties because you're incapacitated yourself, or that you have an illness, or otherwise unsuitable. And I think that leaves room for the judge to decide whether or not a person is otherwise unsuitable to be a guardian. And it could be anything. With regards to your qualifications, you have to submit to a credit check and a fingerprint check, background check. So usually if there are issues within your background that the court can see, then, again, it's the judge's discretion whether or not to appoint you. And certainly no one who has been adjudicated as having committed abuse, abandonment, or neglect against a child can be appointed. I have questions coming up in the applications of various clients. Well, am I being disqualified if I file for bankruptcy? Not necessarily, right? Everybody goes through hard times, and bankruptcy is a legal means for people to have a fresh start. So not necessarily. Can I be disqualified by a juvenile conviction that happened 18 years ago? Not necessarily. You want to put in the application all the explanations that you need to really make the case for your client as the proposed guardian, that whatever happens or whatever the situation is, it doesn't disqualify him or her from serving. So, you ask in general, what are the duties of a guardian? And I can tell you right now, it's a heavy burden. You're taking care of somebody, you're taking over their life, essentially, if you're a plenary guardian. So it ranges from very simple things like reading their mail, paying the bills, to going to the doctors with them, understanding what disease or medical conditions they have and what treatment are appropriate for them. It includes deciding whether they should stay at home and finding help for them to stay at home, or a placement in a residential setting, such as a nursing home or an ALF, assisted living facility. I have found that the guardian's duties are much more encompassing and heavier if the ward still lives at home. And the reason being is that you need, if the ward is frail, prone to falling, or has conditions, medical conditions that need constant supervision, then it's much more challenging for the guardian to install these various services for the ward to be kept at home. Whereas if the ward is in an ALF or a nursing home, where supervision is around, well, I say loosely around the clock, then the duties of the guardian are lightened by the fact that there's other people who share in the care. And interestingly enough, there are cases where the ward is in a nursing home, but the guardian still orders additional or supplemental services, such as a companion, right? So a companion is someone who sits with the ward either at night or during the day, whatever the case may be, to make sure that no emergencies occurs. If you come into the nursing home and you know anything about being in a nursing home, you know that the supervision isn't 24/7, and that the ratio of staff to resident, is not ideal. So that if the guardian feels a need for the ward to be supervised additionally, I had a case where the ward tends to wander at night. He can't sleep at night, so he tries to get out of bed and he tries to, walk around, but he's prone to falling. So in that case, my client guardian, hire a companion to be there with the ward at nighttime. And one of the guardian's responsibility that is, to me, is profound, is whether or not to exercise DNR, a do not resuscitate orders. We had a case in Orlando where the guardian exercised the DNR and the ward died as a result. And so she has been facing felony charges on, relating to his death. And so, it's, again, planning is everything. If you have planned and you decided that, you don't want to be resuscitated if certain events occur, and you have reduced that in writing, it helps the guardian a whole lot, as to what to do when the situation arises. But if the guardian is without directions, then the guardian would have to go to court and petition for the court to decide whether or not a DNR is appropriate. So last year, the statute was amended to provide proceedings, expedited proceedings for guardians and other interested persons to come into court and seek guidance from the court with regards to whether or not a DNR should be exercised. But again, it's not a decision that any one of us would want to take on lightly. And lots of times, you have people who are willing to do just about everything except that. So, that is one of the responsibilities of a guardian. Now, in giving you the overall, sort of like the view from above of the guardianship system, you get the sense that this is not really a thing that people jump in readily or enthusiastically. There's a lot of issues involved, and why would you want to have a stranger to come in and decide matters in your life or your financials, right? So I get a lot of questions from people who watched the movie entitled I Care a Lot. And this movie is on Netflix, and it talks about the guardianship system as a system. Professional guardian, it's about a professional guardian that abuses her power and really harmed the wards that she has, and the outcome of her conduct, if you will. It is a Hollywood movie. It involves a Hollywood star, and it's sensational, And so when you watch it, you say to yourself, "Wow, the system is really horrible. It's really prone to abuse and misuse and so on and so forth. And it gives the professional guardians a bad name. At the same time, you have to recognize that these scenarios as portrayed in the family, in the movie, do happen in real life. So for example, the professional guardian that comes in and wants to be appointed in a case, he or she does it really for financial reasons. They are private or professional guardianship is an enormously expensive proposition. Professional guardian gets anywhere between, they charge by the hour, and they charge between 55 and 85 an hour for doing the things that they need to do on behalf of the ward. And they bill just like lawyers, 1/10 of an hour. And the tasks can be as simple as reading the mail and weeding out all the printed advertisements and see what bills need to be paid, and certain actions be taken regarding the household. And the guardian is also responsible for clearing furniture out of a home in the event that the ward is being relocated. The guardian bills for time sitting with the ward during a medical appointment, or to meet with a panel of medical service providers in the case of a planned, emergency or treatment. The professional guardian also files reports with the court intermittently, and they get paid for spending time in court. For example, certain actions taken by the guardian has to have approval by the court. If you want to sell a car that the ward hasn't driven in a long time and just sitting and incurring costs, as far as maintenance and storage, then you have to have your attorney file a petition to sell the car. And in general, professional guardians don't want to undertake responsibilities that are cumbersome. So one thing we have found out is that guardians don't want to rent out the ward's house if the ward is going into a facility, because that involves dealing with the tenants and making sure that the lease is updated. And so for the most part, if the ward goes into a nursing home, and even though there's no reason for them to have to sell the home, the professional guardian will recommend or will petition the court to sell the homestead if they feel that the ward has no chance to return, or that the ward needs more money to pay for the care in the facilities. And again, we all know if we live at home, it costs a lot less. If we go into a nursing home, I think the average cost now in Florida, at least in our region of the Tampa Bay, is anywhere between $8,000 to $13,000 a month. So let's say the ward has a decent amount of savings, $100,000, $200,000 in savings. Well, you can see that doesn't really last a long time, especially if it's a case involving a younger ward, with a memory issue as opposed to physical issues. So the guardian bills for time, and his or her attorney also bills for time. And if you have other relatives who disagree with the guardian on certain decisions, they also have an attorney and they will contest. So if the guardian wants to sell the house and the family member doesn't agree, they can file an objection, and the objection has to be ruled upon by the court. And so you have a hearing, and you're going to have the court deciding, what to do ultimately. But at the same time, the costs of the guardianship are borne directly by the ward. So in the event, as I indicated to you, if the ward has a couple $100,000 in savings, over time, it's not just the care that costs money, it's also the attorney's fees, the guardian's fees, the appraisal fees, the different things that the guardianship is costing the ward. And again, it all coming out of the ward's assets. In the event that the relative is challenging, his or her attorney is his or her cost and her responsibility, but at the same time, as you can see, I've seen cases where people work hard for a lifetime. They fall under guardianship, and everything they own, gets sold, gets to be sold and liquidated to pay for the expenses relating to their guardianship. And so, it's a fact of life. And I think that is something that, the movie touches upon that really hits a nerve for people who watch it, because, well, how could that be, you ask? But at the same time, that's a statute. That's the law we have in our state, and that's how it is. And, one of the things that I've encountered, every now and then is that unlike other cases in Florida where you're responsible for your own attorney's fees, unless there's a statute or contract that says the losing party will pay your fees. Under guardianship, if there is a fight over the guardian's fees or her lawyer's fees, and you are, as a relative, challenging that fee, it's fees on fees, which means that the guardian's attorney can get fees for fighting or justifying the fees that he or she charges. In our Pinellas County, the hourly rate of these guardianship lawyers run anywhere between $350 and $450 an hour. So if you could just imagine, there's a fight over anything. If there's a fight over the fees that is charged by the guardian's attorney, and you want to challenge it, it requires a hearing. And then if you lose, that attorney can get more money out of your loved one's assets. So that's a feature of the guardianship statute. And it's not anywhere else. The fees on fee situation is only applicable in guardianship cases. So, with all of that that I presented to you, the logical question then is, why not family guardian, right? And again, it's, you have a situation that a son or daughter might have been living away, for some time. and the only contact they have with their parents is just phone calls, emails, and a trip every now and then. And that person, is confronted with the guardianship situation. Do you feel that person should or should not be a guardian for his or her parent? And the answer is that in my mind, it gives the child an opportunity to really rekindle the relationship. We all go about our business. My parents are in their 80s, and I don't think of them every day as needing my help, but they were needing help. And so, and lots of times I hear children who tell me, well, my parents don't want to talk about their financials. They're very proud, they're very private, and they don't want to talk about it. So I have no idea, that they didn't have a will, and they didn't have a power of attorney. They didn't have a living will. And now, the guardianship is upon me to decide whether or not I want to serve. And I can tell you that until last year, the professional guardians can petition for themselves to be appointed. So I'll give you an interesting scenario, but it is real. So let's say I have the scenario of a neighbor petitioning for guardianship, and she files the petition, and one professional guardian gets wind of it and decides that she wants to be appointed guardian for that particular case. So she can freely enter into the picture, not related to anybody, not being invited by anybody, file a petition to be appointed as professional guardian. And so looking at those facts, you can say comfortably, well, this person comes into the picture for no reasons other than financial, right? But last year, because of a couple of cases that were well known in our state, the legislature did away with allowing professional guardians to petition to be appointed themselves. So now they have to be recommended by somebody. And most of the time it's a family member who says, I'm living too far away, I can't do this, I don't want to do it for whatever reasons. And so I would be willing to go with a professional guardian. And so, the relative would be recommending a professional guardian. But at the same time, if there is anything that a family member can do, you think about it, the professional guardian has a caseload. They don't have one or two cases. Some of them have a couple of dozens. And, logically speaking, you want to ask the question, well, how much time can that person devote to my father or my mother? How well does she or he knows about my parents' desires, the food that they like to eat, the places they like to visit. The standards and practice for professional guardian only requires them to visit with the ward once every quarter, once every 3 months. And again, I have family members who show up at the nursing home every day with their loved ones and making sure that everything is taken care of on behalf of their mom or dad. A professional guardian can only devote so much time to each of her wards. And so by far, a family guardian has an advantage of knowing, the person, the ward, and doing the things that are consistent with what the ward would have wanted or expressed when they were well. And so that's one advantage that a family guardian does have. And again, it's not, the duties are multifaceted, and they are difficult and sometimes complex. But if you get the right training, you can do it. And every guardian in the state of Florida has to have an attorney. So if you're a family guardian and you have an attorney who guides you through the process and helps you to answer questions that you have as guardian, then you can navigate the waters, right? It's not impossible to do that. Now, with regards to cost, family guardians can get compensation for doing things that are not family like. So for example, if my family guardian client takes her dad out to dinner for an hour and a half, she can't get paid for that, because essentially that is the duty or what is expected of her as a daughter. But if she goes to the doctor and sits for an hour or two and talk to, 2 or 3 doctors and trying to figure out what's going on with dad, she can be paid for that time. Likewise, if the financials are complex and she needs help and she spends time with the CPA or the financial advisor trying to find, the appropriate investment programs to put dad's money in, then she can be compensated for that. And it's through a petition for fee, just like the professional guardian who submits that petition to the court and wanting to be paid. The biggest benefit is really to put the family guardian closer to, mom or dad or uncle or aunt, whatever the case may be. I have cases with nieces and nephews who step up. I have cases involving an adopted child that was away for a long time for whatever reasons, as far as differences between him and his mother, but he came around and he became a family guardian and did a superb job for his mother, and in the process really rekindled the relationship that he was not able to tend to over a long time. So we live in a society now where we value so much, we put so much value on the independence, and we neglect to really visit with our parents often enough to understand that there's a general decline. As they age, they need more help. As they age, they develop certain conditions that they don't anticipate. And so to have a family there, a family member there is essential for their well-being. And in general, the relationship between a guardian and a ward, in my experience, if it's a family guardian, it has been much more much less problematic. And I'll tell you why. If you're a child and you're taking care of your parents, you get less resistance. If you're a professional guardian, you come in and you're trying to do this, and the person, like I said, just because they're incapacitated doesn't mean that they don't have preferences or that they don't have a voice. And so lots of times they're going to oppose the professional guardian's action. One of the biggest thing I hear all the time that is heartbreaking is, so now, I've lived at home for 35 years and now I'm being relocated to a nursing home because I could no longer handle living at home. And it's this professional guardian who comes in, moves all of my stuff out, putting me in a nursing home, selling everything I own. And again, maybe that decision can also be made by a family member when it's no longer feasible to keep the home. But I can assure you that it's a much more thoughtful debate and discussion among family members than, let's say, a professional guardian who is saying to herself or himself, well, I have 20 wards, I have 10 homes that I have to deal with. And if I don't get rid of this home, then I have to deal with, the taxes, the insurance, the upkeeps, and so on and so forth, right? So there are many aspects of the person's life that can be handled very successfully by a family member as opposed to a professional guardian. And if you follow the news at all, professional guardians, with regard to their activities, there are some that are very troublesome, very problematic. There's a case in Nevada where the business of this professional guardian is actually, if you think of it as an integrated business model, where she owns not just the guardianship business, but also like the appraisal business, and her husband was involved in business, and she received kickbacks from the facilities and the services providers, and she misused her power as guardians to the extent that when she was exposed, there was a whole host of crimes that she and her associates committed. And in our state, you have a case in Orlando, you have a case in Pinellas County, where professional guardians have been involved in exploitations and thefts and things. And so, regarding our society, where we deal with our elderly population in such a way that leaves them in a legal system and leaves them with a lot of strangers other than, rather than families, then you have issues and you have problems, and you hear horrible stories from the media and the documented cases you know about. But what about the cases that you don't know about? Who speaks for these people that are needing, a voice? Who speaks for them? Who looks after them? And for me, I've dealt with several family guardianship cases. In fact, our caseload right now is really primarily just family guardians. There are good things that I see. We don't go to court a whole lot when we have a family guardian because we don't have conflict. If you have a professional guardian and you have family members, then often the complaint is, well, the professional guardian for my dad doesn't talk to me. She doesn't let me see my mother. She makes these decisions that are not financially sound. So there's a lot of fights, when you have a professional guardian involved in a case. And I can tell you right now that guardianship system is a fairly closed system, meaning that you have all these all these players that are the same, right? The typical profile of a professional guardian in our county is that he or she has been a guardian for a long, long time. You will see very few younger guardians. This professional guardianship as a business attracts people who are more mature, retired teachers, retired managers from other businesses. And the probate judges were once guardianship attorneys. So, and then the guardianship attorneys in the county are usually focusing on just guardianship and probate, and they've been around a long, long, long time. So you'll have the scenario where, whether intentional or not, the court is going to give certain preference and credence to the people who appear in front of them often, right? So if I am a guardianship attorney and I have many cases in front of a particular judge, that judge gets to see me and know me from a reputation, from the work that I turn in. And so it could be good or it could be bad. It could be a good deference if I have a good reputation, but it's not necessarily good if I'm not an attorney that is thorough, or that I overbill, or my guardian is the activities my guardians are not well guarded by me. I represent professional guardians and I tell them the pitfalls that I see. I understand that the judge will frown upon certain kind of activities that you do. So for example, the guardian will charge, like I said, by increment of 1/10 of an hour for everything that is being done on behalf of the ward. So looking through the mail, paying the bills, sometime, appearing before judges, I hear the judge say, does it really take you 2 hours to read the mail and pull out the bills that need to be paid? So there's a lot of issues within the guardianship system that we as families could pay closer attention. We could participate in the process to keep it honest, to keep it transparent, not only for us as family members, but for our loved ones who can't speak, who can't participate in their own life affairs. And that's why we are, as a firm, a fierce advocate for family guardianship. We tell you that there are courses that you can take to understand the nuts and bolts. We help you with filing the reports when they're due. And we're there with you when you have an issue that comes up and you don't know the answer. And so it is a difficult and challenging undertaking, but if you do get involved, I believe that we as a society will be better off with less number of guardianships in the court than more. And then I come to, the final remarks, which is what I really want you guys to take away from this training is do all you can to avoid guardianship. I can't stress that enough. And people say to me, you're crazy. You're a guardianship attorney and you don't want guardianship. I said, I want you to avoid it at all costs. And how do you avoid it? You participate in planning. And I'm not talking about just our parents or our aunts and our uncles. For us, I'm in my 60s, I need to think about my particular future. Am I going to end up in a nursing home? Is there a possibility that I will suffer, incapacity? What if I succumb to Alzheimer's, right? None of us want to really think about these events as happening to us, but, they do. And it breaks my heart because my caseload involves neurologists, teachers, judges, and people who were once very capable, intelligent, wonderful human beings, or who are now relegated to a guardianship where they can't make any decisions on their own. They can't speak for themselves. They can't decide where they live. They can't really have any say in the day-to-day. And so for us, we need to really search, our lives and say, do we need right now to have a durable power of attorney? Do we need a living will? Do we need to think about the person that we want to be sitting there with our doctor saying, can I pull the plug for my mother? Does she want to, pull the plug if certain things happen? Again, the lesser restrictive means to guardianships are durable power of attorney, pre-need guardian designation of healthcare surrogate, trust agreements and trust documents that say, I want so-and-so to handle my money. Those are the things that you can put in place to prevent guardianship from happening. And then as far as the new law, I just want to touch upon it's not new, it's been a couple of years now, the Injunction for Protection Against Exploitation of Vulnerable Adult. So this is for that section 825.1035. And what it allows you to do as an interested person is to go into court and petition for a restraining order, right? And it's the same process. You do the petition and it can be granted ex parte, and then you're given a return date. And on the return day, the respondent by now would have notice of the hearing. They would come in, they would put up your case, they put up their case, and the judge can decide on certain remedies, including freezing the assets, that is being dissipated by whoever, the respondent or, his or her associate. It can exclude certain person from the vulnerable adult's home. It can allow for payments, a bill to continue, even though there's an asset freeze in place. So it's very similar to a domestic violence petition. The challenge in this particular statute, however, is that you're going to need the vulnerable adult's consent. And as you know, under an exploitation scenario, that person is being under the undue influence of someone. They're not going to be able to understand what's going on, perhaps. And if they do understand, they don't have the will to say no, or that they're so scared of this person that they can't really express to you to give you consent. So then the statute said, well, if you don't have consent, then you're going to have to file an emergency temporary guardianship simultaneously. So then that brings you all back to, the guardianship scenario. But at a minimum, this new law allows you to sort of like stop the bleedings. And the most common scenario I see when this injunction takes place is when you have a banker who calls and said, I suspect some kind of financial exploitation is afoot because this person keeps, taking the elderly into the bank and getting money, thousands at the time, and then so also, if DCF is involved and they give you a call, or that you learn from DCF that there's some exploitation going on, but they can't do anything about it unless you go and get some protection from the court right away. And then finally, the good news, there is some good news, which is guardianship can be terminated and the rights that were removed can be restored. So just as doctors examining the AIP saying you have no capacity, this happens often when on the annual visit, the doctor of the elderly person in the ward would say, you know, it was a transient condition. Now that 6 months later or a year later, this patient or this person has gotten their faculty back, and we want to go into court and petition for restoration. So you need an attorney to do that. And if you file that petition, then the court has to immediately appoint a physician to examine the ward. And the notice has to be served upon all interested persons, including the guardian, the attorneys for the guardians, and other interested persons. And then they can object to the suggestion. So that is the good news. You know, if there are circumstances warranting restoration, we're, as lawyers, happy to do it and assist the families to really put the pieces of life that have been fragmented back together. And that's all I have for you guys. And I've gone over time, what, 1 minute?
You have perfect timing. Thank you so much for that presentation. That is such a tough topic, but so important to get the word out about what guardianship really means, how to do a family guardianship, how to avoid guardianship. So I really, really appreciate you educating us about these topics. I don't want to forget to announce the CLE number is 2106942, N as in Nancy. Again, that's 2106942, N as in Nancy. And I see one question.
Yeah, I see the question. So every circuit court has on its website lots of information about guardianship, including family guardianship. So your starting point would be to your circuit court. Go to the website, lots of forms, lots of information, including the injunction for protection against exploitation. Okay.
That's good to know. Well, thank you everyone.
Thank you so much, you guys. Thanks for being with me.
Take
All
care.
right. Bye-bye.
Bye-bye.